Imagine this. You've got this great idea for a business, you got the perfect brand name, and you designed these amazing t-shirts. You just printed 10,000 of them, and you've heard from all your friends and family, they want them. They're amazing. And you're about to sell them when you get a letter in the mail from, let's say, a big Fortune 500 company saying, hey, hold on a second, we're using a name similar to that. What do you do?
Boy, that escalated quickly.
All of a sudden, the wind is knocked out of your sails because you didn't do a trademark search. Something as simple as this, something as you have a great idea, you think it's going to be the best new brand since 555 Soul or the hundreds, and you're ready to just take the world by storm. And all of a sudden, now you got this letter saying, oh, it may be infringing on someone else's trademark. It can be devastating and cost you time and money. So I don't want you to run into that. So today we're going to talk about the 4 critical areas of intellectual property and hopefully help you avoid any mistakes like that that could really tank your business. In this video, we're going to delve into the world of copyrights, trademarks, patents, and also trade secrets. Those are the 4 elements that comprise the world of intellectual property. So first, we're going to talk about copyright. Copyright covers books, music, sheet music. It covers performances of some sorts. It's really the tangible expression of an idea. So copyright doesn't protect an idea. That's more along the lines of patents, but copyrights protect the tangible expression of idea. So for example, if I draw a picture of someone and that is my own interpretation of that person, all of a sudden I have a copyright to that. That is my common law copyright. The moment I put it on paper, that's mine. If I write a blog, the moment I write that blog, that is mine. That is my own copyright, okay? It doesn't necessarily have to be registered for me to have a copyright to it. But the advantage of registration is that it gives you rights to essentially enforce that copyright in court. It gives you rights to certain damages, statutory damages, such as if there's an infringement on certain goods. The first infringement is usually between $750 and $15,000. If it's willful, it's much more than that. Those are the certain advantages you get when you register a copyright. Without a copyright registration, you have to prove the actual damages and loss to you. So the difference is that, yes, whenever you create something, the tangible expression idea, you write the most amazing song in the world, that's yours. No one can deny that. But once you register it, now you can actually enforce it against other people. Now you're saying, hey, I created this, and hey, you stole that beat. Hey, you stole that song from me. Now you owe me something. Now you owe me damages because I have protections under the law. It creates a presumption that you own that copyright and that you can actually get damages if someone were to steal it. So remember, copyrights, you own something, you own the tangible expression of an idea once it's actually put out in the world, but to enforce it and to really even make money from that, you want to file a registration for that copyright because that gives you additional legal rights that you would not have without a copyright. Next, we jump to trademarks. Now, trademarks are an area that actually have some overlap with copyrights. People sometimes mix up the two, but a trademark is a protection of a brand. Trademarks are really source identifiers. Trademarks were created, over 100 years ago to essentially protect consumers. And the Lanham Act, which is the act that kind of codifies all the trademark law, is a consumer protection act. So that's something you need to remember, is that when you think about trademarks, they're for the benefit of consumers and is to prevent consumer confusion. So if you create a mark that is confusingly similar to someone else's, that is called trademark infringement. These are things you want to remember when you're creating a brand. If you have a great idea for a name of a t-shirt line or a cosmetics line, you want to make sure that it's not confusingly similar with someone else's. You may ask, well, what if there's all these names are taken in cosmetics or all these names are taken in apparel? Well, you've got to get creative, and there's a lot of great websites out there that help you become creative. You can add certain things to the front of that word, certain things to the end of that word. You want to think about how words sound as well. There's a whole world of branding. There's people who have been paid very good money to create really fantastic brands, but no matter how good your brand is, if it doesn't pass the trademark tests, it's not very valuable. So when thinking about a brand, when going through branding exercises, make sure you do your clearance. Make sure you are clearing those names that you like to move forward with and can really benefit from. For example, when we were designing the logo and picking a name for Carbon Law Group, we rebranded from my own law firm name to a name that could stand the test of time and wasn't so tied to me. We came up with Carbon Law Group after an extensive exercise of thinking about all these different names, what's available, who's using what around the world, who's using what in the US. Then we settled on Carbon Law Group because we loved the name of it. We loved that the carbon is the basis of all organic elements in the world and in the universe. We love that carbon is a connecting element. We love that from carbon comes diamonds under pressure. So there's so many great metaphorical meanings for it. And that's one of the reasons why we chose Carbon Law Group. And then we had a great branding expert help us with the logo, which we love, and the colors. So those are all elements you want to think about as well, but you want to make sure that that name is available and that you can in fact register it. And when you do find a name that's available, working ideally with a trademark lawyer that can help do the proper search, because just start looking online is generally not enough. You now need to also make sure you register the domain names and make sure you're protecting it in all different facets that you might use it. Otherwise, you could end up in a situation where a few months down the line or a few years down the line where you want to expand, all of a sudden that name's not available on Instagram or some other new social network that's out, and now you're in a bit of a pinch. So remember, trademarks are all about source identifiers. They help people understand where goods or services are coming from, and you want to create something that's strong, that's meaningful, that ideally has a strong connection with what you're doing. And the strongest brands are those that are arbitrary or fanciful. And what that means is that there's a spectrum on which brands are evaluated, and the strongest brands are considered those that are arbitrary to what they do. For example, Apple for computers, Apples and computers have no relationship whatsoever, so therefore that's a strong brand. Made up words like Sony or Xerox, those are great brands because those are made up words now that have an association with these goods. Whenever someone says Xerox, everyone knows immediately what they're talking about. They know the company, and it takes time and effort to build those brands, but you want to have something that can stand the test of time and that people can associate with the goods or services that you're providing. On the other end of that spectrum are generic and merely descriptive terms. Those are the terms you generally are not going to get much protection for. Not that they're bad. If I'm Johnny Apple Seller, I create a company called Johnny Apple Seller selling apples, I'm probably not going to get much protection for Apple Seller. I may get it for Johnny because Johnny is unique to maybe selling apples, but not for Apple Seller. So you want to think about, okay, what are you doing? If you're going to be having an apparel line and say, hey, the best t-shirt company in the world, it's going to be very hard to get that trademark because it's generic or merely descriptive. Probably generic because you're just saying that you're the best t-shirt company in the world, and that's probably a bold statement that doesn't really help people understand, okay, who are these people actually? There's not actually a black and white rule to any of this, but these are things to think about when you are branding and going through the trademark exercise. Next, we're talking about patents. Now, patents are a complex area of law that are actually protected by the Constitution. In order to get a patent, you have to have a new and novel invention. Okay, that's critical. That's kind of the basis of the analysis that the USPTO will go through to make sure that your invention is actually patentable. So when you're thinking about designing something or developing something, there's going to be your invention. There's most likely going to be some prior art in that invention saying that, okay, well, we're not going to claim exclusive rights to X, Y, and Z elements of this, especially when you're developing something very complex, maybe something in the software or hardware industry. You're going to have prior artwork that you're going to want to cite as well, saying that you're not claiming the rights to certain elements of this invention, but you are claiming the rights to the utility or design of something else. Now, patents are really important because they help protect the way something works. For example, in a utility patent or in a design patent, you can protect even elements of clothing. For example, even Calvin Klein had a design patent on a type of yoga pants, and they got in a big dispute with another apparel company when they had something similar. So design patents are super valuable, as are utility patents. They help create additional value in your company and are really important to consider when you are developing your IP strategy. Look at patents, look at trademarks, look at copyrights, and next, we're going to talk about trade secrets. Now, trade secrets are another area of IP that don't get a lot of attention because they're somewhat unique and difficult to understand. Now, when you have registration for copyrights, you have registrations for trademarks, you have registrations for patents, you don't necessarily have registration for trade secrets. Trade secrets are protected by contracts often. They're protected by NDAs, by confidentiality agreements. Trade secrets are the secret sauce of a company. They are the Coca-Cola recipe. They are these unique elements of IP that you don't want to disclose, because with trademarks, copyrights, patents, when you file something, you are disclosing what you're doing, especially with patents. People are disclosing the inventions, and oftentimes that dissuades people from wanting to file a patent. When it comes to trade secrets, now you can protect that invention or protect that way of doing things without having to file something. It is now protected by a contract, but it's really important. If you want to protect that trade secret, you have to have that NDA confidentiality agreement in place. Otherwise, you really could risk losing it. You could risk disclosing it, and now you have no protection. So there's a lot of laws that protect trade secrets, especially in the context of government secrets and other types of secrets. But the important thing you need to remember is that trade secrets are protected by contract. And you've got to have a contract in place to protect them, and make sure that those trade secrets are not made public some way inadvertently, because if that happens, then you could lose that right, and all of a sudden that IP is gone. So in conclusion, intellectual property is critical for new businesses. You do not want to forget or overlook this this essential element of starting a business. Intellectual property can be a huge area of value for your company if done right. So therefore, don't overlook the importance of evaluating your IP, create an IP strategy, think about, okay, where do you want to register? How do you want to register? Is this just in the US? Is this globally? Think about what you have in terms of the value of your IP. It's not always clear that you have IP in something because you think that, oh, well, it's just some random thing that someone made. But hey, it could be hugely valuable to the success of your company. So why not look at that critically from the beginning of your business and look to see how much value you can extract from all the IP? Because the more you register, the more IP you have, the more you can potentially sell your business for later and also potentially license out. So they can be great revenue streams in the future. Do not overlook the value of this IP in your business. So fellow entrepreneurs, take the necessary steps to protect your IP. That's all for today's video. I hope you really enjoyed it. If you found this content interesting, you may want to look at the video below that talks about preserving your trademark rights. Again, if you like the content that I'm producing, please like and share, and please subscribe. There's gonna be a lot more coming. This is something I really enjoy doing. I love passing on information. I love educating, and I love engaging with people. So please let me know how we can help and continue to pursue your dreams. And I wish you the very best.